get started. So good afternoon, everyone, and welcome to this Nordic Model Now webinar, Rethinking Consent. We have two wonderful panelists who will be speaking to us this afternoon, but before we get to our speakers, I have a couple of housekeeping points, and then I'm going to talk you briefly through the Nordic model to explain what it is we're advocating for. The hashtag for this event is hashtag Rethinking Consent. So if you're going to be tweeting about the event, please use the hashtag Rethinking Consent. You can type your questions into the Q&A chat box at any time, so please do ask any questions you'd like us to address. Please understand that we may not have time to answer them all, so any questions we can't answer today, we'll consider when we're putting together future events. One final thing, while you're probably all well aware that today's webinar is going to discuss serious sexual violence in detail, I just want to remind you of that now before we begin, because you may find the discussion upsetting, and I want you just to bear that in mind if you do continue watching. So before I introduce our brilliant speakers, I'm just going to take a little time to explain the Nordic model, which is what we're campaigning for, so you know what we're about as an organisation. I'm just going to share some slides as well, so that you can see as I talk you through this. Great. So the Nordic model, which is also sometimes known as the equality model, recognises prostitution as part of the structural oppression of women and other marginalised groups, and is both a cause and a consequence of the persistent inequality between the sexes. The Nordic model was introduced in Sweden in 1999 after extensive research that revealed both the extent of women suffering prostitution and sex buyers' ignorance of the consequences of their actions. The researchers developed the idea of one-sided criminalisation, where buyers, rather than those selling sex, would be the people held accountable. So, first of all, the Nordic model decriminalises the selling of sex. No one should be criminalised for the exploitation and abuse that they endure in prostitution. Secondly, the model invests in services that provide support and genuine routes out of the sexual exploitation industry. Most research shows that about 90% of those who are currently in prostitution want to get out of it, but can't see how to exit. So services accompanying the Nordic model, or part of the Nordic model, need to include access to safe, affordable housing, training, healthcare, childcare, legal and financial assistance and advice, emotional and psychological support, and probably drug and substance abuse rehabilitation as well. Thirdly, the Nordic model makes buying sex a criminal offence, which has the key aim of changing men's attitudes and behaviour and establishing a norm under which no woman, man or child can be sold for sex. The fourth point is that the Nordic model strengthens laws against trafficking, pimping and brothel keeping. And finally, for the Nordic model to succeed, there does need to be a plethora of holistic measures promoting the model, including public information campaigns, education in schools about the harms of prostitution, and training for the police, along with real concrete measures which will actually address the poverty and inequality that lead people into the sexual exploitation industry in many cases. Taking Sweden, where the Nordic model has been implemented, and it's been implemented properly, it's been shown to reduce the size of the industry, and it creates a hostile destination for international sex traffickers. In Sweden, this has also brought about a change in the culture and a change in men's behaviour, and it now has widespread public support, particularly among women and among young people. It's not surprising that the sexual exploitation industry therefore hates the Nordic model and insists that it's actually more dangerous for the women involved, but that is simply not true. Nothing can make prostitution safe. That's why the Nordic model aims to reduce the size of the industry, to give women genuine routes out and to prevent young girls and other marginalised young people from being drawn into the industry in the first place. What the sexual exploitation industry wants is full decriminalisation, which means that all aspects of the sex trade would be legal. That includes the acts of pimps and brothel keepers who are transformed by this model into legitimate business people, where buying sex is completely normalised. In that scenario, because prostitution is regarded as normal and just a standard job, there's no public funding for services to help women exit prostitution. Laws against trafficking are retained, but in practice, given the proliferation of the industry, they're almost impossible to enforce. In New Zealand, decriminalisation is consistently held up by lobbyists as the best approach to prostitution. New Zealand pioneered full decriminalisation in 2003. It's now been in place for 20 years, and lobbyists and even the New Zealand government claim that there has been a decrease in the size of the industry. They claim it's safer for women, that women can refuse clients or refuse particular services or acts, that brothels have regular health inspections, and that condom use is compulsory. However, the data in the New Zealand government's own assessments does not actually support any of these claims. What the data actually shows is that after decriminalisation, there was a rapid increase in the size of the industry, that violence and coercion remain rife, and that in practice, women can seldom refuse clients or refuse specific acts. There have only been 11 brothel inspections in 12 years, even though more than 1,000 brothel licenses were granted during that same time. Unprotected sex is still also the norm. Women report that Johns always or nearly always ask for it. This slide compares full decriminalisation with the Nordic model. The left-hand column shows what full decriminalisation means. Selling sex, pimping, brothels, and buying sex are all legal. And because it's considered a normal job, no public money is invested in services to help people exit the industry. The right-hand column shows the Nordic model. Selling sex is legal, but pimping, brothels, and buying sex are illegal, and there is specific public funding for high quality and holistic education services and support services to provide genuine routes out of prostitution to those involved. This chart uses publicly available data to show the percentage of the population involved in prostitution in 6 countries: Germany and the Netherlands, where they have a legalized system, New Zealand with its decriminalized system, and Sweden, Norway, and France, where they have implemented the Nordic model. There is a much smaller proportion of the population involved in prostitution under the Nordic model than under legalization or full decriminalization. This suggests strongly that the Nordic model is effective in containing the sex industry, if not in reducing its size necessarily, then at least in preventing its further growth. This final slide from me shows the grim reality of prostitution for the lives of the women involved. Campaigners for full decriminalisation often claim that the Nordic model is somehow more dangerous for the women involved. But if this were true, we would expect to see higher rates of homicide of women involved in prostitution in countries where the Nordic model has been implemented, and lower rates in countries that have implemented full decriminalisation or legalisation. The numbers show that women involved in prostitution killed by pimps and punters, expressed as an average annual rate per 100,000 female citizens during the years in which the legislative framework was in place, don't bear out that assumption. It's clear that the rate of homicide of women involved in prostitution is significantly higher in New Zealand, Germany, and the Netherlands than under a Nordic model in the countries where that's been implemented already, Sweden, Norway, and France. This shows that the claim that the Nordic model is more lethally dangerous for women involved in prostitution is simply false. However, we are also not making the claim that the Nordic model is objectively safe for women, because we don't believe that anything can make prostitution actually safe for the people involved. It is a terrible fact that prostitution is the most dangerous occupation of all, far more dangerous than being a taxi driver, a firefighter, a lumberjack, a police officer, or other physically dangerous occupations, which are typically male-dominated. The Nordic model is based on the understanding that nothing can make prostitution actually safe. And so it aims to reduce the size of the industry as well as to help people leave. And the data does suggest that when the Nordic model is well implemented and well supported, this approach is successful. And ultimately, reducing the size of the industry will reduce its harms. Now, having done that introduction, I would like to introduce you to the first of our two speakers, Professor Wendy Murphy. Wendy is a litigator, author, and activist who's been advocating for the constitutional and civil rights of women and children and working within the legal system to combat violence against women and children for decades. Wendy's a former child abuse and sex crimes prosecutor, and she's the founder of the first legal organization in the US which provided pro bono legal services to victims of sexual and other forms of violence within the criminal justice system. In addition to her legal practice, she's held academic legal positions at the New England Law School and Harvard Law School. Wendy also founded the Judicial Language Project, which uses sociolinguistic research to critique the language that's used in law and society to describe violence against women and children. We are delighted to have Wendy speaking to us today. Thank you, Wendy.
Thank you very much, Emily. I just learned even more about the Nordic model than I already knew, and I appreciate the work that you do so much. I'm going to share my screen, so let's hope that works as well as it did when we practiced. Okay, here we are. Can you see? Is it okay, Emily?
Yeah, that's great. Thank you. I can see that fine.
Okay, great. So before I start, I mean, obviously, you can tell by the title what I'm going to talk about. Much of what I cover will be in the context of rape law, but in my view, it applies with equal force to other aspects of exploitation of women that are sex-based, both sex in terms of activity, but also sex in terms of gender. So please understand that when I go through the nature of what consent is and what autonomy is, I'm also talking about the decisions women make to become involved in prostitution. I just don't have my slides focused on prostitution, but they are equally applicable. So first I want to talk about what is autonomy, because my goal today is to help people understand that, oh, wait a minute, I lost my first slide, there we go. To help people understand that there is a difference between consent and autonomy. Generally, when we talk about rape law or the ability of a woman to decide whether to become involved in prostitution, we use the word consent. And my goal today is to persuade us to stop using consent, or at least to use it alongside autonomy, and to prioritize autonomy as both the language that's preferable and that is legally preferable. Before we get to that point, we have to understand the differences. What is the difference between autonomy and consent? They oughtn't be different, but they are. So I'll give you the most basic definitions of autonomy, and then we'll get to the definitions of consent and we'll be able to see. So autonomy in terms of US law, and I should also emphasize that much of what I'm going to talk about for obvious reasons is from US law, but I think things are somewhat comparable in most Western countries anyway. But to the extent there are differences, I think Esther will, or somebody else as well as Esther will point them out. But autonomy is a global human rights concept, and as you can see in my slide, the references I make here use the language that reflects the nature of being a person in charge of one's decision making about our bodies, our lives, our destinies, that it is almost so fundamental that it shouldn't even be codified. It's just too basic as a human rights ideal and an actual legal concept. It is about liberty. It is about the right to be let alone, as the United States Supreme Court well-known Justice Brandeis said many years ago, it is the most valued right of civilized people, and that it speaks to these concepts that we hear a lot about but don't necessarily apply when we're talking about violence against women or prostitution. Freedom of will, dignity, integrity, individuality, self-determination, and the absence of external causation. To me, and Dworkin's definition really speaks to this, perhaps in the most broad sense. It's simply about being able to decide for yourself how you're going to live your life without any form of external coercion. Now, that's an idealized sense of what autonomy means. There's also the reality that we may not be able to function as human beings free from coercion, or at least influence from external factors, but that should be the goal. That should be the goal if we in fact agree that this is a human rights value worth protecting, enforcing, and endorsing. I like to put at the bottom, because it's not really a legal concept, but it's something my students really nod at when I say it. Everybody grasps quickly this idea that my right to swing my fist ends before it hits you in the nose. This is sort of an old adage. And then I think just extending that to the idea that, not to make this about swinging penises, but that goes for all body parts. All of your rights as a human end before they interfere with someone else's rights. Then this is the essence of autonomy. Feminist ideas about autonomy have a little bit more focus to them. And these are just a few examples that I wanted to share, because not all, and that's why I have feminist in quotes, not all feminists have the same views of what autonomy means. And I would argue that the less robust definitions come from non-feminist spaces. Certainly this notion that it dates back to the early days of suffrage, this idea of self-determination and authority over the self was critical to the suffragists who were fighting just for the right to vote, and the idea that they ought to have existence as human beings. They certainly embraced this concept of autonomy. And yet in the context of things like sexual assault and prostitution, there are quote unquote feminists who would argue that it is respectful of autonomy to allow a woman to choose to enslave herself, to choose to exploit herself, to choose to subjugate herself, that there's some kind of autonomy and freedom built into that idea. Most feminists, I maybe even should say true feminists, reject that idea outright, because it's akin to saying, Black slaves in the South were expressing autonomy when they chose to live on plantations and resisted freedom for whatever reason. And there were some slaves that resisted freedom because they were afraid, for good reason. It is by definition not an autonomous decision when you choose to be enslaved as an alternative to being beaten, killed, or lynched if allowed to be free. And I think we have to apply that same concept when we think about the choices that women make about their lives. Okay, so in the law itself, when we think about autonomy, this is the, I suppose, framing of autonomy in law that maximizes legal protection. I would not say it guarantees protection for autonomy 100%, but it maximizes our ability to respect the concept and to make sure that the government is doing all that it can to ensure that the concept has meaning in practice. In other words, when you get into a courtroom and people are discussing what consent means, there are all sorts of issues that come up about the legal definition. Well, here's what autonomy looks like when it is best protected. And I should emphasize these aspects, these modifiers, really don't apply in consent law, but they are, in my view, an idealized way to structure our sense of consent, because they do maximize protection for autonomy. And that is to make sure that a decision is knowing, that a person has capacity and competency to make the decision, and that that decision is free from coercion, that it is voluntary. So knowing, intelligent, and voluntary are the modifiers that ensure that the word autonomy and or consent, however we, whatever word you're talking about, whether you're having a conversation about what consent means or what autonomy means, it doesn't have much value in law unless we have these modifiers in place. So here are some examples of ways we protect autonomy. Again, even if you stuck the word consent in there, I'd be saying the same thing. I am going to argue that, I'm going to argue, and I have another slide on this coming up, that 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 consent is a proxy for autonomy in law. Autonomy is the fundamental human right. Consent is the technical legal word we use in law. These are some examples. Privacy rights. Everyone knows what we mean when we talk about privacy rights, the idea that human beings have individual authority as against the state in particular, but the idea that privacy as a concept and as a human right encompasses the notion that you get to decide who knows things about your life, when to let somebody intrude into your space, and so forth. This is just another way to describe what it means to have autonomy, that you have things called privacy rights. Liberty is another fundamental concept in law that embraces this notion of autonomy. In some countries, they use the language of due process. That's what's used in the United States. But liberty and due process are ways of providing space for that word autonomy to be given value. And in the law, that's in fact where it happens. Sometimes they call it privacy, sometimes they call it liberty. They always refer to it, when it is referenced, as a fundamental right. Again, to harken back to this idea that there is something so basic about the idea that you can control your own destiny, that of course we have to think about it as a fundamental right. And some scholars have actually said autonomy is so fundamental we ought not codify it, because that would make it vulnerable to legal interpretation and abridgment. And let's not do that. Let's make it so fundamental that we don't even put it in writing. And then I put that at the bottom, Miranda rights. For those who don't know, this is just in the United States, the idea that before you can give up your right to remain silent in a criminal case, before you can be, in a sense, forced to become a witness against yourself, you have to be advised that you have the right to remain silent. And this is also one of those rights that applies in most countries that have democracies or civilized legal systems, that you cannot be forced by the government to testify against yourself. Well, this is obviously an expression of our respect for individual autonomy. And how do we really respect it in practice? We don't let you give up that right unless your waiver is knowing, intelligent, and voluntary. In rape law in particular, I want to talk about autonomy now, just focused on what we know the definition of rape law is and what's happening to autonomy when we define rape law the way we do. Not all states and perhaps not all countries define rape this way, but this is a common definition, and it is the definition where I live and in most states in the United States. There are three essential components if you want to prove that a rape happened. There has to be penetration, there has to be a lack of consent, and there has to be proof of force. I want to say, before we even get into a further discussion about the meaning of without consent, that this additional requirement that there be force present in addition to non-consent, force is something added, right? So force is a separate element. There has to be force in addition to non-consent, which means there is absolutely nothing in rape law, when this is the definition, that protects autonomy at all, because unless force is used, non-consensual penetration is allowed. And if non-consensual penetration is allowed whenever there is no force used, you have just created a law that not only permits rape, but also has zero regard for autonomy, because your non-consent is irrelevant. Very important to remember that. Now, we have a trend going on in this country where many states are enacting laws to remove the element of force. So in some states, they do now have a crime, excuse me, they have a crime essentially called penetration without consent. But there are problems with doing that, and I'm going to explain, because what they've done in states where penetration without consent is now a crime, they've upped the definition of consent. And I don't mean upped in a positive way. They've changed the definition of consent to be much harder to prove and to be much less meaningful on this issue of preservation of autonomy. So there's been a quid pro quo there that, in my view, wasn't worth it, was not worth it for the quid pro quo that went through when they went through the legislative process to create this new crime that looks good. But is it really? Here's a way to think about the devaluation of women in particular when we define the crime of rape, that I think most people are familiar with, but to the extent you haven't thought about it this way before, it's important because it allows us to then say, wait a minute, how is it we are protecting stuff more than humans? It's a hard argument for the government to justify. So I like doing this comparison, but I gave you the prior slide on how we define rape. Now I want to explain how we define theft, to really showcase the absurdity of ever requiring proof of force as a necessary element to establishing that rape occurred. In many states, the crime of larceny is the taking of property of another person without consent. That's it. If force is also used, it becomes another crime. Well, the meaning of consent as defined in theft crimes includes a much greater regard for the autonomous ownership interests of the victim. So these kinds of comparisons are important, because if you're trying to talk about the devaluation of women as a class of people, it's a powerful argument to make that you can show what theft requires in terms of elements of the crime, and how it's easier to prove a theft crime than a rape crime, and how utterly inhumane, absurd, and discriminatory that is. Are there things to which we cannot consent? Yes. And why is this important? Because much of what we let women consent to technically fit the definition of things we have described as so inhumane that we don't let any human consent to these things. This is, at least in theory, how we function. And I suspect this is true in all countries with civilized legal systems. The definition of torture, which I haven't laid out, but it doesn't matter. I think we all understand the concept of what torture is. Torture, by definition, international law, local law, state law, it has a definition, and that definition includes this phrase: one cannot consent to torture, or the defense of consent cannot be asserted when a torture charge is filed. This is the way that the government, the state, messages people: don't even try to argue that a person willingly submitted to this, even though they did, because we will not tolerate that. It is uncivilized, it is inhumane. We don't let human beings consent to torture. The same is true for slavery. You cannot choose to be a slave. It's illegal to choose slavery. We won't respect you. We don't care if you tell us that this is your free choice, this is your free will. It is the epitome of, I don't know what the right word is, that one cannot express free will and by choosing slavery, right? They don't go together ever. So the third category, which used to be here pretty comfortably, but this is changing thanks to pornography, is force. It used to be that a human being cannot consent to the use of force against their body. This was pretty well established in the States many, many years ago, that, you know, if you hit somebody across the head with a baseball bat, you're going to be charged with a crime, and you cannot argue in court that they wanted you to hit them in the head with a bat. You just can't. Why? Because we don't allow human beings to submit to conduct that might cause them serious bodily harm or death. You cannot consent to it, period. These are per se unlawful acts to which a human cannot consent legally, even if they consent factually. So regardless of how the victim feels, regardless of what the victim says, you cannot consent. And these are concepts that describe the experiences of women, not only in rape, but also in prostitution, pornography, the so-called rape industry. As I said before, consent is a proxy for autonomy. So the meaning we give to consent in rape law is important, because if it doesn't honor the nature of free will and self-determination, then it really isn't a proxy. It is, in fact, a legal mechanism by which we diminish autonomy by simply calling it something else and incorporating restrictions. Consent in rape law is defined explicitly to undermine autonomy. Here's why. First and foremost, most rape laws have no definition of consent whatsoever. What this does in the legal context is, when the issue of consent is in controversy, the decision makers, the people who get to figure out whether there was consent, are generally speaking human beings who get to use their cultural understanding of what consent is, and that imposes on the idea of consent all kinds of restrictions that we have given our culture that allow less than fully autonomous decision-making to take place in sexual context. So when the law abdicates its responsibility to define consent in the way that I suggested, knowing, intelligent, and voluntary, we have just given, the state has just allowed the meaning of autonomy to be abrogated, because it refuses to modify the word consent with appropriate features that explain what consent is and help us understand how it relates to this precious idea of autonomy. Some states, and I know some countries, have adopted words, relatively recently, phrases like affirmative consent. I forget what the European language is. It's something like this. And this has been both highly lobbied, there's been a lot of lobbying around this, and highly funded lobbying, celebrated, you know, it gets lots of attention, which by the way should always make us suspicious, right? But affirmative consent not only has done nothing to help us establish the meaning of consent to align with autonomy, it has in fact elevated the ability of the state to diminish the meaning of consent, because that word affirmative has its own legal definition that I'll get to in a minute, that detracts from the subjective experience of the victim and gives a lot more value to objective observers' thoughts about her consent. So that word affirmative is a real, it's a bug, because it looks good, but it's the wrong modifier. It's the antithesis of knowing, intelligent, and voluntary, and I'll tell a little bit more about that in a minute. Same is true of other kinds of modifiers. There are a couple of states that have allowed the use of the phrase freely given or voluntary to be added to rape law, but they're very limited. Those opportunities are very limited. And in any case, they then don't define voluntary. They then don't define freely given. So how meaningful are they? I will just add at the bottom that, and I know this is, again, true for most civilized legal systems, that you don't have to prove non-consent when the victim is incapacitated or incompetent. But the level of incapacitation and incompetence required to establish that a crime occurred because there was incapacity or incompetence is so high that you have to be almost unconscious. And what's missing here in terms of respect for autonomy is lack of respect for diminished capacity or diminished competency. Someone who's in between fully competent and completely incompetent or incapacitated, those are not autonomous events either. Those are not autonomous decision-making moments. But again, the law has no regard because they don't incorporate this concept of diminished. How do offenders' rights play a role in all of this diminution of the value of autonomy in rape law? This is really important and a little bit more subtle, harder to see, because we're talking generally about what courts' decisional law, appellate courts making rulings on cases. So it's less black and white to the public and to the common observer. But most courts will give weight and consideration to an offender's state of mind, which by definition offsets the value that law can recognize in a victim's subjective non-consent or consent decision. In other words, a victim can 100% not consent, but if the law values the offender's opinion of her non-consent, then by definition, she's got less than full authority over the self. Mathematically, I'm going to show you a slide in a couple, in the next one or the one after this, to show you what I mean visually. But I hope this seems obvious, that the law ought never give weight to the offender's opinion or state of mind. Oh, I made a mistake. I thought she consented. Because whatever amount of weight the law gives the offender's opinion or state of mind is an offset against that 100% authority over the self that autonomy reflects. Okay, so here we go. So this is autonomy to me. Visually, 100%, the concept of 100% ownership over the self is reflected. This is how the law works, with the idea of consent being offset by an objective observer's opinion about a subjective experience of the receiver of harm. So if the law gives the harm doer, this is what's reflected in the white, if the law gives the harm doer 15% weight in their state of mind, if the harm doer's opinion gets even that little bit of weight, this is the diminution you see. It's really a one-to-one, I think, correlation. You've just declared as a matter of law that this is how much autonomy women have. It's not 100%, it's 100% minus whatever that amount is that law is willing to apply to the harm doer's decision, the harm doer's opinion about the woman's actual autonomous decision. So how else is autonomy diminished in law? Well, we know it's not just in law, I should say. How else is autonomy diminished and not respected? People have diminished autonomy from a variety of experiences, whether they're intoxicated because they have mental health issues, because of their age, if they're incarcerated, if they have a disability. Women have a unique way they experience diminished autonomy. I call it per se diminished autonomy because they lack equality under the law. Especially in the United States, women do not have equality under the Constitution. We don't have equal protection of the laws. We were excluded from the Constitution's guarantee of equal treatment under the law back in 1868, and we remain unequal today. It's why we've been fighting for the Equal Rights Amendment for 100 years. We still don't have it in the Constitution. Well, obviously, this gives women less legal value in everything, in all laws. because it creates constitutional conditions of dominance. And when the Constitution creates dominance and subjugation in its foundational legal document, autonomy cannot exist for the subjugated class, no matter what laws are enacted, because those laws are then subject to unequal enforcement, unequal treatment, et cetera, by all government officials in all branches at all times. The foundational legal document has to create equality, and in my view, it also has to expressly embrace autonomy. That's where you get the benefit, the most benefits. The foundational legal document has to embrace these ideas. And I think the other thing I want to emphasize here is that culture can create non-autonomous and coercive conditions. And I think we all know this, regardless of what the foundational legal document says. We live in a culture where women make decisions in coercive conditions all the time, in their lives, in their homes, in their decision-making about their jobs, and so forth. So the question is, how should law respect this? What ought we be saying about the nature of consent that reflects an understanding that women live in inherently coercive conditions culturally? What should we be saying and doing? Because there's nowhere in law that this is respected, this idea that women function in inherently coercive conditions at all times, including when they make decisions about what to do with their bodies, whether to become involved in prostitution and pornography, etc. So how can we maximize, this is my last slide, I'm not watching the clock. Please let me know if I'm going too long. How can we maximize the legal value of autonomy as activists and supporters? First and foremost, we have to fight to eliminate all state of mind defenses in rape law. From my experience and what I see in the States is that no one is focused on fighting against the defense bar's arguments, both at the trial level and on appeal in the policymaking courts and even in the legislative branches, that there has to be more legal valuation of the defendant's state of mind, that if the defendant thinks he has consent, that has to be respected, regardless of whether the victim actually didn't consent. There is no organized effort to fight against this, and it is growing like wildfire in the States. I suspect it's growing in other countries as well. It's happening without opposition, and that's very problematic considering what's at stake. Now, I bother to say, I don't mind if a defendant in a theft case says, I thought it was mine. I thought she gave it to me. I thought this was something that I was supposed to take custody of because I made a mistake. I thought that property of hers was mine. It's okay to have a state of mind defense in theft cases because it's at least theoretically possible to own someone else's stuff. It is not ever possible to own another person. This is what's at stake when we make decisions about letting a perpetrator of a sexual offense, or even a decision around, writing up a contract to let a woman choose to participate in porn or prostitution. Everything we do that deviates from that knowing, intelligent, and voluntary form of consent / autonomy is aimed at making sure that we don't allow law to create an ownership interest in men over women's lives and bodies. That's what's at stake. We say we don't allow humans to own each other, but we have laws that actually do allow men to own women. And I'm not overusing that word. I think if you have control over someone's life and destiny, you do, in a sense, own them. And our rape laws and particularly our legal definition of consent is what permits that ownership to happen. What else can we do? Well, we have to teach autonomy at every opportunity, use it in every legal brief, never just write about consent. Always write about consent as an expression of autonomy, always use the language of autonomy, always cite those core concepts that I used on the first slide that express this idea as a human rights issue, as a fundamental rights issue, as something that goes to the dignity of human existence, etc. Use those big words and that, those big concepts in everything you do when you talk about consent. Embrace and sort of tether the word autonomy to consent to make people appreciate what's at stake. If we just use the word consent, we've abandoned our obligation to help people understand what's actually at stake when we either define it or try to codify it in some fashion. We can take responsibility for always using the word autonomy, and not just using it because people might not know what it exactly means, but using its meaning. Get some good, solid, foundational legal definitions of autonomy that sound in human rights, so that you're elevating the weight of what you're talking about every time you debate or talk about or argue about the use of consent. And again, it's regardless of whether it's in rape law, prostitution, pornography. That concept is so vital, and we have the power to use our language to keep those two things tethered at all times. If you can, try to codify its value by proposing that the word consent, especially in rape law, be defined. Like, we should not be living in a world where the legal system uses such an important word without defining it. You cannot leave juries and judges to their own biased and really affected life experiences to come up with a fair understanding of consent on their own, because they are infected by their cultural and legal experiences. They're never going to understand consent as this 100% concept around that is meant to surround autonomous decision making, unless you tell them that that's what consent means. And the best we can do, I think, at this point is to codify these words, knowing, intelligent, and voluntary, because those become all about the subjective experience of the victim. Was it knowing? Did she have enough knowledge? Did she have enough intelligence? And was it voluntary, including in a cultural context? These are beautiful words that give us the right to talk about the victim's subjective experience of consenting, rather than the perpetrator's objective and usually incorrect opinion about her consent. Let's borrow from laws we know that people respect, such as waiving your right to remain silent, consenting to serious medical procedures. You can't consent to a serious medical procedure unless it's knowing, intelligent, and voluntary. Well, let's talk about those sorts of things. And in terms of what's voluntary, there's been a lot of talk about how youthful offenders shouldn't have to face adult consequences until they're over the age 25, because the brain isn't yet done developing by age 25. And so let's not punish them as adults. That may well be true. I have no doubt it's true, but that also works for females, right? If a woman's brain is not done developing until age 25, why are we letting them, quote unquote, consent to prostitution, pornography, or for that matter, sexual activity? Brain development is related to that idea of knowing, intelligent, and voluntary. Well, let's, make sure we're having that conversation about the subjective experiences of victims too, from that brain isn't yet done developing perspective. Fighting sex bias in all aspects of legal proceedings. To me, this is a very much uncharted area. We do very little, aside from talking about it ourselves, we do very little to bring legal pressure to bear on police who discriminate against women by not arresting, by prosecutors who discriminate by not prosecuting, by prosecutors who, when you have to vote for who a district attorney is, we don't challenge them to prove that they are going to spend the public's money correctly in terms of how much of the pie is devoted to violence against women. We have done very little to hold these government officials accountable, but we've also done very little to ensure that juries, when juries sit in judgment in matters involving violence against women, we don't screen out jurors who have deep biases against women, or who, you know, are porn addicted, or who you know, are members of incel organizations. I mean, that we don't have anyone in this country, we don't have any law in my country, maybe you do, that allows for the screening out of jurors who are members of incel organizations, you know, who are members of an organization that seeks to kill women. We don't even exclude them. So these things about fighting sex bias are a little bit tangential to this issue of consent, but it's related enough because it's all tied together. This idea that there is a sense of male entitlement in how some of the decisions around consent are determined by government officials and juries. That sense of entitlement is both a constitutionally enabling problem, but it's also a cultural problem that we can do more about, regardless of whether we do the constitutional fix first. Make sure all hate crime, civil rights, and anti-discrimination laws expressly state that women are a class of people. This seems so obvious, but the reality is there are moneyed interests behind the effort to keep women divided and not thought of as a class. You know, other people can be a class, women can't be a class. This is a political thing that's been happening to women for a very long time. Sometimes I write briefs and I use the phrase women as a class, and I'll get my opponent will write a brief back and put the word sick next to that, because there is this sense that women don't deserve their own status as a class of people. Well, we can, language alone, we can keep using class-based terminology and in that sense affect how people experience conversations about the suffering women endure because they are female. It's a class-based problem. So we have to stick this class-based language in everything. We have to make sure that when there are categories developed in law that talk about things like hate crimes, civil rights, and anti-discrimination, that there's always a seat at that table for women, because we're not there. We're there in some spaces, but not most, certainly not all. And we can do something about that, even in our language. So while we're working on actually changing laws that add language like this, we can just do it with one another. And of course, my bottom line is, and this is my final point, we really do have to fix our foundational legal documents to confirm that at the baseline, women are equal human beings. They're entitled to equal treatment under all laws and by all government officials at all times. And so long as women aren't understood to enjoy that baseline equality in our foundational legal documents, the law itself will be the cause of all of this stuff we're talking about. High rates of violence, exploitation, prostitution, pornography, et cetera. Because if a constitution doesn't ensure women's right to equal treatment, it is by definition the driving force behind their unequal treatment. And unequal treatment means the laws that exist, whether they are laws against rape, prostitution, pornography, torture, slavery, whatever the law is that says this shouldn't happen, those laws will be enforced differently and worse on behalf of women because they aren't entitled to equal treatment under any laws. If you're not entitled to equal treatment under all laws, you will be subjected to unequal treatment under all laws. And that's why the constitutional baseline is so important. Women don't have equality in the United States. We proposed an equal rights amendment many years ago. It has been ratified by the requisite number of states. 90% of people in this country support the idea of women's equality, but there's so much money against women's equality that it just isn't happening. And it's money that funds both political parties. So women don't even have a way out by the political process. We can't vote for a certain candidate and hope to establish our equality because the money that opposes our equality funds both major political parties. It's a problem. It's a very serious problem. To actually transcend this political stalemate, women have to mobilize as a separate class, politically and otherwise, be fiercely nonpartisan, and refuse to use their millions of votes to support either party unless they do the right thing in terms of establishing our equality once and for all. But we have no leadership in this country to help that happen. This is the key problem. There is no leadership. To the contrary, there's an enormous amount of pressure to always to divide women, because the divide and conquer strategy has always been successful to keep us politically impotent. And I think we've reached a stage where we can see it and rise up against it. But again, there's no leadership. So my primary concern is that so long as women lack basic legal equality, we have no choice but to submit ourselves to an outrageous definition of consent that has nothing to do with, or non-definition of consent that has nothing to do with autonomy, because we're not entitled to autonomy. Women are not entitled to self-determination and control over their lives and bodies. This is probably the most important concept we can embrace when we're talking about what's missing in the law, while we are simultaneously focusing on rebooting our constitutions and our foundational legal documents. But make no mistake, even if women got into the Constitution and were finally declared fully equal persons, there would be a way for the legal system to still characterize us as unworthy and second class. And that's because the money that's being made in porn and prostitution, and of course, therefore rape, because what happens in porn and prostitution is rape. The money being made in that industry is unbelievable. I mean, we're talking about hundreds of billions of dollars. And when an industry is that wealthy, changing legal definitions isn't necessarily going to make much of a dent. But this is why I am so supportive of and really love what the Nordic model is doing, because they're acknowledging that the moneyed interests are enormous. We can never marshal enough funds to prevail against it, but we can make a dent. We can bring things down. We can bring women up. There are little things we can do along the way. And my view is that the one thing we can fight about when it comes to this issue of consent is refocusing people to appreciate that autonomy is important, that women don't have it or enjoy it when it comes to rape law or decision-making around prostitution and pornography. And part of the problem is that it doesn't yet have visibility as a focus of our activism. So today, I hope I leave you with the idea that we can change our focus on this one issue. We can change our focus simply by using the word autonomy.
Thank you so much, Wendy, for that stirring call to action at the end as well. That was incredibly illuminating. Although the laws obviously vary in their details internationally, the concepts that underpin rape law and wider laws affecting women are universal. So your analysis is really valuable for all of us in the UK and globally. So thank you. I'd now like to introduce our second speaker, Esther. Esther is a Nordic Model Now member and survivor of the sexual exploitation industry. She has a long-standing interest in research into public policy approaches to sexual violence and domestic abuse. And we're very grateful to Esther for sharing her insights and her analysis with us today. Thank you.
Hi there, could I have the slides up? Hi, I'm Esther. I am a survivor of prostitution and pornography. I'm going to talk to you a bit about porn, prostitution, and public understanding of consent. Can I have the next slide? So a bit of repetition here with what Wendy said, but some states, by which I mean kind of jurisdictions, countries, and in different states in federal systems, don't define what consent is, but they may have a legal age of consent and particular conditions that they specify about an adult's capacity to consent. And the main difference between states' laws are between definitions of consent. This is when they have a definition of consent, definitions based on adults with capacity having not given consent, that's a consent-based law. Definitions where consent is based on having been forced to have sex through violence and threats, that's a coercion-based law. England and Wales, I'm mainly speaking about England and Wales here, has a consent-based law for rape and sexual assault, but it's subject to the defendant's reasonable belief that the complainant consented. I mean, differences between the member states of the European Union about whether a new EU directive on violence against women should include a consent-based definition of rape and assault, actually, but it turned out to be so contentious that it's resulted in rape and sexual assault being removed from the directive altogether because no agreement could be reached about that. Can I have the next slide? So the offences of rape and assault by penetration, sexual assault, causing another person to engage in sexual activity, those are in our Sexual Offences Act 2003, that's the main act. They require the prosecution to prove beyond reasonable doubt that the defendant did the act and firstly acted intentionally, and secondly that the complainant did not consent to the act, and then thirdly that the defendant did not reasonably believe that the complainant consented. So if a jury is working out whether or not a belief is reasonable, which is the jury works out, they have to consider all the circumstances, including any steps the defendant took to work out whether the complainant consented. There's no requirement, though, that a complainant demonstrate or communicate to the defendant a lack of consent. Can I have the next slide? So this is our statutory definition of consent. A person consents if he agrees by choice and has the freedom and capacity to make that choice. So that's interesting reading that and just after what Wendy has been saying. Give me the next slide. So this is the reasonable belief test, and it's a subjective test, but it has an objective element. So the Crown Prosecution Service, which is the kind of responsible for the main state prosecutions, they recommend that prosecutors deal with this issue by asking two questions. Firstly, did the suspect genuinely believe that the complainant consented? That relates to the suspect's personal capacity to evaluate consent. That's subjective. The second part is, if so, did the suspect reasonably believe it? And the jury would decide whether this is belief was reasonable. So that's objective belief. And so what's sort of required is some evidence to be put before the jury about lack of consent. And the nature of that evidence would depend on the circumstances. So it might be that the complainant was incapable of consenting or knowing even what was happening because of the influence of drink or drugs, for example. That's one example. And in working out whether the belief was reasonable, a jury also has to have regard to all the circumstances, including any steps the suspect might have taken to establish whether the complainant consents. So these could include sort of suspect attributes such as disability or extreme youth, but they wouldn't include something, for example, like whether or not suspect has any particular fetishes. We have the next slide. So this slide and the one after it, they're about presumptions about consent, which are set out in the statute. So that's circumstances where a defendant would not, which is what these are. This is the first one, conclusive presumptions. This is where the defendant would not be able to use consent as a defense. And the one after is about where they might not be able to. So, I mean, have a look at them because they often occur in porn films, and porn viewers may take this to mean that what was filmed wasn't rape and wouldn't be considered rape if they did what was filmed in real life. So the first one, having proved that the defendant did the act, was that the defendant intentionally deceived the complainant about the nature or purpose of the act, or intentionally induced the complainant to consent by impersonating a person, pretending to be someone who was known personally to the complainant. Those two are conclusive presumptions that there wasn't consent. We have the next slide. So these are sort of, they're written quite technically, but this is where you might not be able to say that there was consent. So firstly, if at the time of the act or just before, any person was using violence against the complainant or another person, or causing the complainant to fear immediate violence will be used against her or the other person. If the complainant was unlawfully detained and the defendant was not. If the complainant was asleep or otherwise unconscious. If the complainant would not have been able at the relevant time to communicate to the defendant whether she consented. And if the complainant had been given or had taken without her consent a substance which could cause or enable her to be stupefied or overpowered at the time of the act. So I think it's interesting to reflect on that when you look at some of the things that are regularly in pornography. So if we have the next slide. Our Domestic Abuse Act 2021, it clarified by restating in statute that a person is unable to consent to actual bodily harm or more serious injury. That includes intentional strangling or breath restriction, which would amount to the offence of battery. There's a kind of limit above the actual bodily harm and above you cannot consent to. There are exceptions for some activities like sports within their rules and things like that, but that's the main line. And the government has said it's intending to introduce a statutory aggravating factor for cases of manslaughter involving abusive, degrading, and dangerous sexual conduct. So what that means is that it would allow a higher sentence for these types of homicides. That follows a lot of concern about homicides which involve rough sex and lower sentences. And this also would be available where the death occurred as a result of a victim's vulnerability following sexual conduct. So could include failing to seek medical attention after sustaining injury during sex. So this is a different, I thought I would mention this because I think it's quite interesting in connection with consent and other issues. This is our offence of coercive or controlling behaviour, which was created by the Serious Crime Act 2015. So it's demonstrated by if two people, A and B, are personally connected, and A repeatedly or continuously engages in behaviour towards B that is controlling or coercive, and the behaviour has a serious effect on B, and A knows or ought to know that the behaviour will have a serious effect on B. A is committing this offence, coercive and controlling behaviour. And the effect is serious if it causes B to fear on at least 2 occasions that violence will be used against her, or if it causes B serious alarm or distress, which has a substantial adverse effect on B's usual day-to-day activities. And so the ought to know there, about A knows or ought to know, that is what a reasonable person in possession of the same information would know. And so it's a defence to this offence for the A to show that engaging in the behaviour, A believed he or she was acting in B's best interests and that the behaviour was in all circumstances reasonable. But that defence isn't available where the behaviour caused B to fear that violence would be used against her. So because you quite often see coercive or controlling behaviour in porn as well, so I think it's worth and there's certainly aspects of prostitution which are coercive, so that was why I put that in there. Can we have the next slide? So online pornography and the companies which own porn websites, they're competing in a global online environment for viewers' attention. That global online marketplace, because it is, includes many depictions of serious violence, torture, murder, and mass destruction. And this global marketplace operates outside domestic or national laws and definitions of rape, sexual assault, and unlawful physical violence. Human rights organizations condemn many acts of sexualized violence and degradation which feature in online porn as torture or inhuman treatment, which, as Wendy mentioned, is prohibited by human rights treaties, and you cannot consent to it. If these acts are carried out or acquiesced in by state agents, they count as torture, but you see them very frequently on these above all national borders porn sites. We have the next slide. So sex buyers, they practice these sort of scripts which are derived from porn on prostituted women, sometimes to find out whether they enjoy them themselves, but very often before using them more widely. And in this way, they progress to being considered mainstream and performance, like acts in a bucket list. And viewers, which include teenagers and even children, don't receive these sexual scripts as man bites dog outlier examples of behavior, but as part of an international rote memorized sexual curriculum. Research carried out by Dr. Fiona Vera Gray and colleagues at Durham University, which was published in April 2021, they looked at ways in which mainstream pornography positions sexual violence as a normative sexual script by analyzing video titles on the landing pages of the 3 most popular pornography websites in the UK. And the study was unique because it focused on the content that would be immediately advertised to you as a new user. And researchers found that 1 in 8 titles shown to first-time users on the first page of mainstream porn sites describe sexual activity that constitutes sexual violence. More recent research in France showed that the proportion of porn titles shown to first-time users which describe activities constituting sexual violence has actually increased since this study was published in 2021. And Pornhub's position as the most popular mainstream pornography site hasn't been affected by recent accusations of monetizing videos of rape, sexual assault, and other acts of violence, and numerous lawsuits relating to human trafficking. I think it's interesting that sexual offences have been removed from the criminal law modules studied by, in many criminal law modules studied by people seeking professional legal qualifications in case they're triggering. But these images which may constitute these offences are on display online everywhere. So that some of the time it's actually useful to know if what you're seeing is illegal in real life. We have the next slide. So online porn very often associates sex with pain and degradation. Directors seek to produce fearful or distressed reactions or require neutral responses to violent and painful acts. Because these responses are more popular, the cruelty is the point and it's the money earner. Injuries and harm inflicted on women during porn shoots are edited out. This would mean you did not get a meaningful understanding of the likely consequences of some of the acts depicted. Performers may have to sign agreements consenting to what happened to them during a shoot and stating that they weren't harmed before they get paid. And even where that isn't the case, complaining or being seen as difficult will affect how you're seen by directors and whether you're cast again. So there's a reason why you don't hear much from porn performers about the nature of the industry until they've left it. Have the next slide. So another aspect of porn is, and also prostitution, is giving the illusion of pleasure. Viewers of porn and sex buyers often fail to recognize that porn performers and prostituted women are performing acts, roles, and personas for a financial reward. They assume the stereotype that women in prostitution are more highly sexed than women outside the sex industry. And women who've left the industry often find that men they have relationships with who are aware of their past expect them to perform in their intimate lives in the same way they did for financial reward. And this is one of the this enables men who watch porn or pay for sex to ignore circumstances in which women become involved in the sex trade and promotes the belief that the women they pay made choices directed by their sexual desires. This is a myth propagated and perpetuated by the sex industry because the biggest threat to its business model is unpaid sex. At its heart, the sex industry is extremely socially conservative, regressive, and it's invested in maintaining gender inequality. We have the next slide. So online porn sort of creates expectations about sex, performance, and also body image, which can make both women and men feel inadequate and be physically and psychologically damaging. Men can feel pressure to perform like porn performers, whose performances are frequently enhanced by drugs. The camera angle, rather than sexual pleasure, is the priority for directors. Condom use is not obligatory, and use of lube in scenes involving anal sex is often discouraged because the director wants to capture expressions of pain. And exposure to online porn contributes to ignorance about the risks of serious harm, injury, trauma to the body and mind, and even death from some acts, because these risks are minimized in the interest of entertainment. Can I have the next slide? Excuse me. So this bit is about coercion and peer pressure. And women, especially young women, may feel pressured to receive or submit to certain acts, like anal sex or rough sex, for fear of being labeled prudish, rather than because it's something they desire. I saw quite a sad thread on X Twitter a couple of months ago, where a man had asked a question: what are the things that you get the impression from porn women like but find they don't like? There was a very long thread, which was mostly things around anal sex and choking, but with sort of somebody pointing out that sometimes a woman will say that they like something because they think that a man won't be attracted to them. The man thinks a woman likes that because because she says so. And then it's a bit like the bit in My Fair Lady, the song where Henry Higgins says, so rather than do either, you do something else which neither likes at all. So it can have quite a bad impact on that. And group sex encounters involving multiple men and a single or smaller number of women are often arranged to initiate newcomers into a group as a bonding exercise, which may bind members of the group in future. And pressure to perform to stereotypes of masculinity in a group situation like that can override boundaries a man might well have observed outside the group. I encountered that quite very often, where I was certainly aware that not everybody in this group was equally enthusiastic about what they were getting into, but that there were reasons why that they had to impress the other men who were there. Can we have the next slide? So these are different newspaper headlines. The first one is from 2018, and it was a report of an online survey of nearly 4,000 people carried out the same year. And a third of the respondents said there had to be physical violence for sexual activity to count as rape. A third of males and a fifth of females said it wouldn't usually be considered rape if a woman had flirted on a date. The younger respondents were reported to have held views more closely aligned to the law. More than a third of over 65s didn't regard non-consensual sex in marriage or a relationship as rape, compared with 16% of 16 to 24-year-olds. And 42% of over 65 said if sexual activity continued after a woman changed her mind, it's not rape, compared with 22% of 25 to 14-year-olds. The over 65s would have grown up in an era when domestic violence and domestic abuse wasn't taken seriously at all and wasn't really in main discourse, and when marital rape wasn't even considered a crime. That ended with the House of Lords judgment in October 1991. The second headline there, the one in blue, that is from a report published on 26 January this year of a survey of 3,000 adults commissioned by the Crown Prosecution Service to collect recent evidence of how the public view rape and serious sexual offences and the law on consent, reflecting the changing nature of sexual behaviours. And this was to help inform its handling of rape and prosecution of rape cases. That survey found that while the public's accurate understanding of rape has grown over the past 20 years, there are still significant false beliefs, misunderstandings, and misconceptions. It also revealed that misconceptions about rape have moved into the digital age, with a focus on the behavior of victims online. Given the results of that survey I mentioned from 2018, 6 years ago, the response of 18 to 20-year-olds was alarming. Only half recognized it can still be rape if a victim doesn't resist or fight back. Less than half recognized rape victims may not immediately report to the police. Less than half recognized that being in a relationship or marriage does not mean consent to sex can be assumed. Less than half recognize that if a man has been drinking or taking drugs, he's still responsible if he rapes someone. And young people were far less likely to understand that if a person says online they want to meet up and have sex, that does not mean they have to have sex when they meet. So as the 18 to 24-year-olds are likely to have had more exposure to sex education in schools than older ones, this suggests that the misconceptions are evolving and being spread in digital spaces, that digital spaces have more influence than what they're being taught in school, and that this will be doing the same for those under 18, which is causing serious problems now, as you will see from the third and fourth slide, and presents serious challenges for the future. The police actually said that the involvement of minors as offenders those 3 and 4 slides, is exacerbated by the accessibility of violent porn. The 5th headline, this is from February of this year, is about an inspector's report which concluded that the Metropolitan Police, which is the largest force in England and Wales, is failing to effectively deal with child sexual exploitation, leaving vulnerable young people at risk. They had serious concerns about its performance and said it lacked understanding of the nature and scale of child exploitation, which was a significant barrier to being able to address it, and that this was shown in some cases by the choice of language of people who were expected to be protecting children. But it isn't only young people who have these misconceptions. The media colludes when news items say things like, "A man was convicted of having sex with a 12-year-old. That's rape of a child, as in England and Wales, a 12-year-old can't consent to sexual activity." So our Domestic Abuse Act 21, which I mentioned earlier, defined domestic abuse for the first time. And it includes abuse within families as well as within intimate relationships. Intimate relationship itself is not restricted to a connection of any specific duration. So include a single meeting with somebody. The types of behavior which are specified as abusive include physical or sexual abuse, violent or threatening behavior, controlling or coercive behavior, economic abuse, and psychological, emotional, or other abuse. And this can consist of a single act again, or any of these types of abuse, rather than a course of conduct, which used to be how things were seen. So as we're talking about the use of language today, it's worth emphasizing all of those types of behavior come within the umbrella term violence against women and girls, which the Home Secretary recognized as a national threat alongside terrorism in February 23. Scottish Government also regards prostitution as a form of violence against women and girls and has recently published a strategy to improve support for women involved in it, including providing exit routes. The UN Special Rapporteur for Violence Against Women and Girls, who visited the UK this week, also emphasised violence against women and girls as a national threat. In June 2023, the National Police Chiefs Council published updated guidance on prostitution-related offences, in which it said that prostitution was not necessarily violent. This suggests that they think violence against women and girls only includes physical or sexual abuse. It's a similar view to thinking that it isn't rape if she doesn't fight back. And this view is intended to justify failures to enforce our laws against sex buyers and those who profit from the prostitution of others and their collaboration with the drivers of demand. It doesn't align with the range of behaviours identified as abusive in the 2021 Act, which are violence against women and girls and worthy of attention. Thank you.
Thank you so much, Esther. That was really fascinating and informative. We are now going to have a few minutes for questions, which people watching submitted in the chat. I'll ask Wendy a question first, give Esther a moment. So the question we had first, Wendy, is how can one translate into legal language the idea that consent in a particular specific context may actually be invalidated by a lifetime, years of slavery, abuse, or marginalization?
Yeah, very good question. So, you know, how consent works in a specific case is dependent on our ability to define it for all cases in a way that respects the real meaning of autonomy. And as you heard from Esther, I mean, I didn't know this, but UK law is a nightmare, if you ask me, because they've already codified enormous respect for the state of mind of the perpetrator, which by definition means whatever the life experience or subjective experience of the victim, it's going to be offset by the weight that law affords his state of mind. His opinion can trump and override her subjective experience, whether or not the subjective experience takes into account her long history of suffering and whatever else her life experiences have been. But the number one thing we can do to at least maximize the value of the subjective experience of the victim is to make changes to the meaning of consent, and in some cases just frankly define it, because the biggest problem in the United States is it's not defined at all. But define it with the modifiers I kept mentioning, knowing, intelligent, and voluntary. Why? Because the word voluntary in particular at least gives us the opportunity to ask questions about her life condition. If her decision has to be voluntary, then it becomes relevant. All the coercive conditions that affected her decision, including her life history, become relevant. Why? Because the word voluntary is case contextual. If she wants to talk about whether her decision was voluntary and the nature of it not being voluntary is tied to her life history, she gets to talk about it. Until we add those modifiers, knowing, intelligent, and voluntary, to the legal meaning of consent, she doesn't have a legal right to talk about anything. Because it's not relevant. Nothing is relevant unless you make it relevant. And we create relevancy around the subjective experience of the victim, including her life history, only if we add those modifiers, knowing, intelligent, and voluntary. I know that I saw one of the questions mentioned, well, what about enthusiastic consent? I mean, we've got this silly, nutty stuff going on. Let's have affirmative consent. Let's have enthusiastic consent. None of that allows us to ask these questions about the subjective state of mind of the receiver of harm with regard to her capacity, her intelligence, and her cultural and historical life experiences. All of those give meaning to that autonomous decision-making that we're trying to give value to. But first we have to make people understand why autonomy matters. Then we have to explain why consent is a proxy for autonomy. And then we have to define consent in law to give value to what it means to have an autonomous decision. That's where knowing, intelligent, and voluntary come in. So I urge everybody to fight, never, ever, ever support things like enthusiastic, affirmative. No, those are not state of mind focused. Knowing, intelligent, and voluntary are. So those are the things that we can and should be fighting for. And no one is. I mean, that's really the important piece. No one's focused on that because we get told what we're going to support. Like, oh, something gets propped up. Here's affirmative consent. And all the corrupt groups start marching behind it. We love affirmative consent. I remember I was giving a talk in California when it was first proposed there, and they were cheering for it. And I was the only one on the panel saying, no, why would you support this? This makes no sense. It's really hard to fight against what everyone else is saying is a move forward. But, we got to take charge of what a real forward move looks like. And it looks like autonomy, or it's not a forward move.
Yeah, I agree with that, because I was going to say that there's a Judicial College kind of guidance, Crown Court kind of compendium. They guide judges in what to say to juries and directions to juries about things. And there is a bit in there about what happens in sort of consent issues. It's trying to, and the jury's supposed to be able to distinguish between consent and submission. The sort of submission is not consent, etc. But there's a bit where it's talking about somebody if you're in a long-standing and loving relationship, that if you didn't actually want to have sex, but in the interest of preserving that relationship, you agree to it. That was. And that's like when you think about lack of understanding about the formal, the freeze response being a stress response, or who defines what is a loving relationship, and it's as if, but around in that way, what used to be the ban, the marital rape was not a crime until 1991, but now it's like being in a long-term relationship can influence whether the longer it goes, the less you lose your autonomy. And it's a bit like saying, sort of stay for the aftercare, and anything you say may be held against, say or do may be held against you. And that's I'm sure that wasn't their intention, but that's what it looks like to me. And the other thing that I was going to say about sort of the enthusiastic consent thing, that's so common in prostitution, because you have to perform this outward performance of enthusiasm, and otherwise you might get a bad review or something. So that you have this big division of your outward self from your authentic self, at the same time as you might, in similar way to somebody who's been in a long relationship is going to be suppressing their authentic self. So on both sides, the actual autonomy and that person's authenticity is undermined, and it's often kind of a buyer's requirement. So if you were saying it always has to be like that, well, that isn't telling you anything about. It's like assuming a certain thing. It's like assuming that anybody who's sad will cry. So it's a really odd way to look at kind of the psychology of it.
Yeah, you're making it you're saying that the focus is on the objective. It should only ever be a subjective test. That's exactly right. I totally agree.
Yes.
Thank you both. Just following on from that, I had a question. There are, for example, strict liability offences in the law, and you both talked about the analogy with different parts of law and how we can see what theft is, we can see what coercion is in other contexts, but somehow not in the context of sexual abuse. Do you think there could ever be a development of the law more towards that strict liability model where the subjective belief of the perpetrator is made irrelevant? Do you think that could be a way forward?
Well, that is how rape law was originally designed. That's why they call it what's the right word? A general intent crime. The intent has never mattered. The intent of the perpetrator has historically never mattered. It has grown to matter over time as more and more moneyed interests have taken hold of what rape law is defined to be and how we deal with the issue of consent. I mean, I don't like the phrase strict liability, because even when it's a 100% subjective question, the issue of consent is both 100% subjective and entirely mental. It's not physical, right? Like whether you consent is a thing that happens in your mind. Your body, and this is I think everybody would agree that there are times when your body might be doing things that seem consensual, but your mind is not consenting. We have to always remember that it's a subjective test because the decision to consent is in your mind. And we don't want anyone else's opinion of your mind to matter because they don't know your mind. They can never actually testify about what's in your mind. Well, in that sense, it's not a strict liability crime. It's just a crime that respects autonomy. So you still have to prove that it was non-consensual, right? In other words, the government still has to show, even if we give zero regard to the state of mind of the rapist, the state still has to show that it was non-consensual. And if the victim testifies that she was thinking it was non-consensual, but she was physically performing consent, a jury is not going to find somebody guilty of that. And a prosecutor probably wouldn't even file charges, even though it's technically a violation of autonomy and a violation of consent. So we have to remember that safeguard is in place, that you don't want the decision maker to be able to say this was not a rape because in my opinion you consented, because whether you consented is only up to you. But a prosecutor can say, but I don't think I can prove the charge beyond a reasonable doubt because I don't think it's a strong enough case based on the evidence that you're going to testify to. That's where you get the protection against what some people might say is the problem of strict liability crimes. Like we have strict liability crimes when a child is raped. Let's say they're age 14 and the rapist is their boyfriend who's 16. There are many states where that's not even a crime anymore, but let's assume it is just because we have a strict line in the sand around age. Prosecutors still choose not to file charges where they're close in age and it's a factually consensual relationship, even though technically you're under the age of consent. So we do this all the time. There are strict liability crimes where you might worry that the state might have too much power. But the point is that the line in the sand is drawn to protect children as a class, even though some children are capable and in situations that we don't want to criminalize. We draw the line in the sand around autonomy, even though we don't want, men who, for good reason, thought they had consent. We don't want them to go to jail, but you draw the line in the consent with a subjective standard because you want to maximize legal protection for this basic human right to autonomy. And it's kind of like, it's a strict liability crime if I bash you in the head with a baseball bat, right? Even though you're begging me to do it, you want me to hit you. And if I do, I'm going to go to jail, even though you wanted to do it. So there's strict liability there because the law has said we want to protect human beings, even as against their own bad decision making, because we don't want people hitting each other in the head with bats, even if they find it desirable. The problem is that line about we don't want people to consent to harmful behavior because it's inhumane has really shifted against the well-being, especially of women, because of the increased violence in pornography since the advent of the internet. Now, and you know, these crazy books like whatever that 50 Gray thing is, you know, once you normalize and eroticize violence, you have to move the line a little bit. So that we used to forbid people to submit to or consent to harm that might cause a risk of death or serious bodily injury. That line is moving now because defendants do go into court and say, yes, she had a ripped vagina. Yes, she had a black eye. She wanted me to do those things to her. And defense attorneys will turn to the jury and say, you know, many of you watch porn. Many of you read 50 Shades of Grey. You know what I'm talking about. And they all nod. So we have a problem because we get sometimes so over worried about strict liability to the expense of protecting against even the most grotesque, inhumane things. We let women consent to torture in porn. Clear torture is happening in pornography. Torture is happening even in prostitution and in private bedrooms. The thing that happens to women fits the definition of torture. And we have zero prosecutions for torture, even though the law says you can't consent to torture. This is the problem.
Thank you, Wendy. I'll just ask one more question and then we'll probably, in the interest of time, have to wrap up. But we had another question. Esther, perhaps this is one that you could speak to particularly. The question was that advocates for prostitution use human rights and autonomy arguments to support their position that women can agree to do as they wish with their bodies. So how can this more progressive understanding of autonomy help in terms of our laws in the UK, particularly around prostitution?
Well, I think I was actually looking at earlier at there was a really interesting book written by two German legal academics, which they very conveniently did a PDF of in English of the summaries about they're criticizing their legalization of prostitution in Germany, but their references to it very much what Wendy was saying, to do with violation of human dignity, which is the first article in the German Constitution, and the issue of kind of dignity is what they are talking about, and that is how you would work out sort of issues around autonomy and things like that. I also think some of the advocates for full decriminalization, they've abandoned the kind of the ideas about kind of social sort of economic equality which they used to have, and because it's a big bar on gender equality overall, and so that they are much less concerned about that, and they have become very much invested in kind of neoliberal attitudes about choice, where some of the other states, especially if they've got welfare nets and things like that, are much more concerned about. Because there have been big increases in the number of women who become involved in prostitution and the sex industry in general because of the impact of austerity budgets, which disproportionately impacted on women and marginalized women, migrant women, women from ethnic minorities, much more seriously affected. And it's sort of regarded almost as a reason not to do anything about the underlying structural inequality there. And they seem to have given up a lot of those arguments.
Can I say one quick thing, Emily?
Of course, please do. Yeah.
My response would be, in addition to Esther's nice setup, I would say the benefit of using autonomy conversations in fighting back against this idea that women are expressing their autonomous choice to participate is to say you're begging the question. When you say women are expressing their free autonomous choice to become involved in prostitution, why are you not first unpacking the meaning of free autonomous choice? When you say this woman has chosen to become involved in prostitution, why are you not asking what is the context within which she made this decision? because I think we should debate the meaning of the word free. You can't just declare, this is the real problem. You can't just declare in a contract, I am making a free choice, because the nature of making a free choice requires an assessment of the law, the culture, the circumstances, the conditions. If a woman, is it possible in theory for a woman to choose to be enslaved and it really is her free choice because she wants to be maltreated? Is it in theory possible to choose enslavement? And my answer is yes. But do we as a civilized species ever want to respect a human being's choice to be enslaved? Answer, no. That's not just my idea. It's what we said to enslaved Black people around the world. You cannot choose slavery. So imagine if we said to them back then, oh, because this is what I hear those people saying. When they say, come on, autonomy is let's let the women choose. I say, would you have said that to Black slaves? Would you? Because some might have chosen to stay if you had said you can make this choice. Would you have said, we will respect your autonomous choice to live in slavery? And if the answer is no, because I know it's no, now you have to tell yourself why. Why would you deny a person the choice to be enslaved? What's at stake? Why do you feel that way? And why do you lack the capacity to apply that same reaction to women who choose slavery in a different form? This is what we need to do. And I'm not suggesting that, all aspects of Black slavery are exactly the same as all aspects of prostitution. I'm saying we don't even ask that next question when someone says in writing, this is my free choice, whether it's a contract to appear in porn or a decision to participate in prostitution. We just see it declared, this is my free choice, without asking the next question. And that's disrespectful to those women's autonomy, because it doesn't even analyze whether that free choice is in fact free.
Thank you, Wendy. There was one more comment actually in the chat, which I think perhaps if you could both just briefly address, I think that would be a great way to end. Someone said, rule number one is always follow the money and ask who benefits. And so who is it that you see who benefits, particularly financially, from consent laws being the way they are? I don't know if Wendy, you'd like to go first. Thank you. Then
I've got a lot to say about that. I wanted Esther to have a chance to go first. I will tell you exactly what the answer is, and I think everybody knows this. The porn and trafficking industry, a global multi-trillion-dollar industry, makes enormous profits if the meaning of consent is not the same as the meaning of autonomy. In other words, so long as the meaning of consent permits harm, and it currently does, they maximize their profits. What would happen to their profits if the meaning of consent were changed to reflect my definition, which is that consent has to be knowing, intelligent, and voluntary? They'd have fewer women in prostitution. They would have much fewer pornographic films made. And it would be easier, this I think is the most important issue, it would be easier for activists like us to mount legal challenges to the industry. We could sue pornographers, we could sue prostitution businesses and argue that they're not consensual decisions, right? Because we would have this definition that allows challenges to the declarations of consent that aren't challenged. So I think it would also, because it would undermine profit margins, we have to appreciate the moneyed interests playing a role in creating our legal system's problems. They don't do it openly. Very often, porn and sex trafficking industries lobby through proxy groups, which I'm sure all of us already know this, but they lobby as big tech in the United States. They lobby as the ACLU. The ACLU is heavily funded by porn, and yet they have this reputation as doing benevolent work. and that's good cover for when they then argue about the importance of disrespecting women's actual autonomous decision making. They come across as benevolent because they're a seemingly respectable organization. To me, they're not. They lobby in terms of preventing opposition by funding organizations like rape crisis centers, battered women's programs. I mean, this is the saddest thing of all, I think, that we actually have these organizations that are propped up to create the appearance that they care about violence against women and that they're doing good work to stop it, but they're receiving money from the industry. And therefore, what they do instead of trying to actually stop any of this exploitation and violence is they manage the victims in the aftermath. For the most part, you know, they do provide nice services. That's great. But if you're in the business of providing services to people who are harmed, you're not interested in making yourself obsolete, which is what you ought to be doing, right? You should be working toward having no clients. And instead, to the contrary, these are groups that over the course of time have demanded and gotten increasingly large sums of money, including money from organizations that profit from them not actually doing what they're supposed to do, which is to work on stopping the violence. So, I mean, once money is involved, and it's that kind of money, you have to appreciate how they participate in keeping things bad for women, and that includes controlling all branches of government, you know, not just lobbying in the legislative lawmaking, but influencing courts, filing briefs, influencing advocacy groups to make sure that respect for women's autonomy is never a thing. Because if we ever actually reach that point where women's autonomy is a valued thing, their profits they just plunge, and there'll be they won't put up with that. I mean, it's really about money, and we will never have the money to beat that back. I concede that. So the only thing we have is each other and the power of unity and the ability to say things out loud that people aren't saying, and to call out, you know, corrupt organizations, and to, you know, shine a light on the inhumanity and hope somebody cares someday. But money always wins. It's always about money, always.
Thank you, Wendy. Esther, did you have anything you'd like to add?
No, I think that's pretty good.
Money. I agree. Thank you so much. I'm going to bring the question session to an end. Thank you so much, Wendy and Esther, on behalf of Nordic Model Now and everyone in the audience, for sharing your time and your incredible insights. This has been so valuable. Before we wrap up, I would like to highlight as well 3 actions that we suggest that everybody could take now to make some positive change. I will bring them up now. First, please sign our open letter to the Council of Europe and European Court of Human Rights. Last week, the Council of Europe published an opinion piece by the Council of European Human Rights Commissioner calling on all member states to adopt a human rights-based approach to sex work, by which she means fully decriminalising the entire prostitution system. She did this while the European Court of Human Rights, which comes under the auspices of the Council of Europe, is considering a challenge to the Nordic model legislation in force in France. And in England and Wales, that sort of behaviour by a high-ranking official during an ongoing criminal trial would be seen as a contempt of court and a very serious matter. But she seems to be unaccountable. So we've prepared an open letter calling for accountability. It's an international issue, so you can sign the letter from anywhere in the world, either as an individual on behalf of any organisation that you represent. Secondly, we will. I'll put the links to how to sign the open letter, and we'll put all this information in the on the website, and when we publish the webinar online, in the links to the video. So secondly, please sign our petition calling for a ban on commercial sex websites. Commercial sex websites are today's red light district. They've made buying women for sexual use easier than ever before. This petition has been up for a while, but if you haven't signed it already, we would please encourage you to do so. Finally, please follow us on social media and share our posts and events. It only remains for me to thank our speakers again so very much for their time and generosity, and thank you all for attending the webinar, and we look forward to seeing you again and hopefully at an event in person.